Gotta get gotta get a better screen here.
There you go. Hey, welcome to another week of our unnamed live stream for the IMMpact folks, and it's also we're half crew today. Chuck is still recovering from a medical episode, but he was texting this morning. He said he almost was ready to come back, but he actually had a conflict that couldn't today. But maybe next week, maybe the week after, we'll see. And hopefully he'll be back. I know he's texting like crazy and emailing again, so he is sort of has his head kind of back in it. And Aaron had a conflict as well today. So you just get Jesse and I, and we will we'll give you. There's also not a ton of updating on the cases, but we'll go through that. And if anybody is out there, you're welcome to ask questions. I guess we'll see in a minute who's here. But Jesse, the biggest group of plaintiffs we have, aside from the whole class for the Ukraine cases in the 601A group. And I'm just wondering if we have any news to report on that. And I will tell people also what the data table is showing as well. So is there news on 601As?
No, I mean, other than, briefing is ongoing in the 9th and the 4th as well. I mean, I know just there's chatter out there about people who are filing maybe their own individual cases and trying to, get relief that way. And, I don't know how many people have been successful with that approach. It doesn't look like the government has changed its method of processing. I mean, what are you seeing in the data?
Well, we have had some more cases approved since last week. So we're at 30 now out of the 298 that we're tracking. The cases that were approved were February 7, 2020 filings on there. So they're relatively early. We did have some July approvals the week before, July 2020, I should say. But it is we're still not seeing much of a pickup, and we actually still have a number of cases that are older than the ones that were just approved. So that's that's good evidence for us that they're not moving these cases in order, even within our own class. In our own group of plaintiffs, they're not moving the cases in order.
And again, I think that is one item we've definitely learned. They didn't even try to say they were following a rule. Right. They basically were just like, courts, you can't look at this.
Right. We can do what we want.
We can do what we want, and we are doing what we want. And I don't think that this is going to be, again, if the court were ever to say, well, this is something, this is normal. Courts look at this stuff all the time. I don't think that the government is going to have a good argument that they're following a rule of reason, so to speak. I don't see that happening. I just think that the government, to their credit, have done a pretty good job at convincing courts that nobody can tell them what to do on this case.
Right. All right, so that's the 601As, and more obviously we're going to get questions on presumably on that. On the 601 case, we did some people may have seen there was a motion to dismiss on there, and that was just for a plaintiff that has actually been approved, and that person has been dismissed from the case, and that was all done, and that's actually fairly common on there. And at some point we'll do that as well with these 30 people who've been approved in the 601A case. Usually the government asks us to dismiss people that are no longer, meaningfully in the case. So, but that's what that was about. I don't think there was any other news on the 601.
Yeah, no, there's just a question on when that individual filed, and I'm looking that up. So hold on just a sec.
Okay. I don't think I have that information handy, but if you have it, that'd be good.
I will check it out. Let's see here. I can do it. I'm going to do it right now.
Okay.
Well, not exactly in real time, but oh, here we go. I am on it today, January 18th, 2022. That goes to the lucky man T. Lyons who asked that question. January 18th, 2022 is when that particular plaintiff in our Boulay case filed her 601 waiver.
The 601 processing times are pretty similar to the 601As as far as the backlog goes. So that is a that is a pretty telling that they are, that it was a 2022. It's only a year old, that case, or a year and a half old.
Yeah, I mean, it's
well,
is what it is there.
To the extent we can get, right. So obviously that only matters to the extent we actually get to make that argument on there, and it sort of brings up this bigger theme. I think what we're seeing with the government, which is a lot of fighting on not the substance of whether of these cases, but on the procedure and whether they need to be reviewed at all, whether we're filing in the right court. These roadblocks that they're putting up so that they don't actually have to get to the issue about whether they did something bad or not.
Oh,
that's ultimately what they're trying to avoid. And that's probably a good place to transition as well to talking about the Ukraine case, because that's the perfect example of where the government has yet to actually discuss the conduct and has only been about procedure. They haven't actually tried to say in any respect that anything that they've done, either in Shumlina or in this case, was justified or correct. And they and we're seeing that certainly, I think, in the new case, where they are, they're saying that we filed in the wrong court. They're saying that they, on there that the class certification can't be determined yet. I mean, basically all the outside procedural questions are up, but not whether they actually owe the money.
yeah.
And and I think that's kind of telling, is that they won't actually make that argument.
Well, it's very. I mean, we know that that the Ukrainian case, and right, they agreed to forego people from having to pay fees. They're finally going to actually listen to what the law says, but not for the people who they screwed over for 6 to 8 months, whatever. It is very similar to what they've tried to do, that with Afghans and special immigrant visas, right? There's a law. Congress says, hey, this is important. Get to it. Here's a timeline. And the career officials, I don't want to say they intentionally, but they don't come up with a good plan to do what the law says they need to do, right? For SIVs, it's for Iraq and Afghanis, it's like 120 days. They have to take action and do a step. And they lost that case in court in DC in the IRAP case. And it's a great case. It's a fantastic case. And they said, the judge was very nice to them and said, hey, listen, you come up with a plan, but you gotta actually do what the law says, okay? And then, of course, our own administration had a kerfuffle over there in August of 2022 in Afghanistan. And the government came back and says, oh, wait a minute, this changes everything. And the judge was like, what are you talking about? I told you have to actually, there's a law that says you actually have to do something for these people who applied years ago. Do it. And honestly, this case is now in the DC circuit. So it's, I'm not saying that that's where our case is going, but we really, I really think the government is really pushing the limit on this Ukrainian fee case, because these individuals are refugees who did not have to pay for these EADs, and it's ridiculous. I mean, honestly, I don't want to say that they should, I don't want to say sanctions or anything like that, but I mean, God, I mean, if there was ever a case where the judge were to say, hey, let me hold on for 1 second. What the hell do you mean that you don't have to pay back the money to these people, but you now understand that no one has to pay? Explain it to me, please, like I'm 5. And I honestly, and I think a judge is going to end up doing that. I don't care where we are. And I know that the litigation can go many different ways and they want to go to a different court, not this court. I just think at some point the government's arguments are going to have to face reality, and they're going to have to go into some court and say what exactly they're trying to say. But it honestly, the money that they're spending to pay the lawyers to defend themselves would be better off spent paying the refugees. I mean, right? It's so stupid. It is ridiculous.
Yeah, and they're going to lose this case. The only question I think that they're grappling with is how expensive the loss is going to be. I think that is basically the nature of the discussions that are probably happening at the agency, at USCIS and DOJ on there. I don't think that they are, I think if we're successful procedurally, and as soon as we get to the point where they're going to have to make an argument regarding whether the refunds are owed, then I think they're going to be, and my prediction is they're probably going to settle or try and settle at that point once they have no choice but to actually make public arguments to try and say that they don't owe the money. On there right now, they're trying to, I think it's all about how much money, and I think they figure they're going to save a lot of money if they can either obviously get rid of the case on procedural grounds, saying, hey, we didn't say that you couldn't get the money. We're just saying you need to refile this in the other court, or, on there. But I think that's, if I had to sort of guess what the conversations are looking like, it's not so much, I think there's sort of a, question of like, we're going to have to pay this money. This is this liability that's out there. The only question right now is whether DOJ can help us minimize the amount of money that it's going to have to be. Yeah. That's the way I see it.
I don't know. I mean, honestly, I really, it's really hard to, because again, I think there's an attorney perspective at DOJ and there's a client perspective, which is the agency. And, sometimes we see this all the time. Attorneys are trying to get, technicalities and get cases thrown out. Hey, you didn't have a search warrant, so even though I have 100 pounds of cocaine on me, it's not my fault. I think also, though, I mean, you have to be careful. I mean, and again, this goes both ways. You're making a judgment that it'll be less expensive later. Right. It's like when there was actually this famous lawsuit of this rapper right out in California. He shot like Megan Thee Stallion or something like that. Right. And they offered him like a very low plea deal. He says no. All right, go to trial. He gets 10 years. Right. 10 years behind bars. So for the government to be like, yeah, if they came to us and they said, here's the list, let's work on this together, they would probably get the best deal ever now. I don't think the deal's waiting for them later from a judge or from us. So I think the judgment call is, let's throw it out. Let's see if we can win. If we can win, great. We'll delay having to pay this. But ultimately what we're losing, and this is the fault of the government. I really do. And I've done it myself. I say it all the time. They're taking the human element out of this, because the money is not really just for attorneys. It's really for the people who paid it that didn't have to. And they probably need it more than anybody else. Yeah. So why wouldn't you just do the right thing?
Yeah. Well, one thing they could do that would probably help themselves is actually deal with the Social Security Administration issue, which is the other issue that we're raising in the case, which is that the Social Security Administration is forcing people to have to get employment authorization cards because they're putting an annotation on there that says it's not valid for use for work unless you have they're saying that unlike refugees, but we believe that they're doing that because USCIS is telling them that that's fine to do that. That they don't have to treat them the same as refugees, which is why we're arguing that USCIS is responsible for it and not Social Security Administration as far as what's on that card. But in any case, they could fix that problem. Could be fixed now, and they've chosen also not to deal with that issue.
But again, it goes back. I mean, the running theme that we're seeing, whether it's in immigration or other areas, is Congress, when they do anything, which is rarely, but when they actually do what they're supposed to do and, pass a bill and make law, you have the executive branch is like, we don't like that.
I know. We've only had like 5 immigration bills in the last 10 years.
But exactly. But in each case, I think, I don't know if in each case, but like they have really great intentions. They're right. It takes a crisis to get anyone to do something. And then you have the executive branch who's friggin', either turn their backs to what Congress has said, or slow walk it. And the funny thing is, again, I don't want to teach civics here, but Congress passes it, but the president has to sign it, and he's the head of the executive branch. So if he signs it, that means he meant it. And so if you work for him, executive branch, USCIS, DOS, DOL, Social Security, like what the hell? Like you can't just sit there and say, maybe, right? We're really busy. We're really busy. I mean, it's like, I don't know. I mean, it's just that argument only seems to work in government. I mean, if you and I did that to our clients, right? Hey, I gave you this money. You said you were going to do something for me. I'm busy. So I'll just keep your money. How about that? It doesn't work in the real world, but like, that's how the government is acting. I think in a lot of cases for people who've paid in, who have family members over. I mean, what they're doing, not to talk DV for a second. I know that Go and Gomez and everybody's going to ask questions.
We have a question also on that.
The major screw job this year, besides, I don't know if it's a screw job, but I mean, they over-selected. That doesn't really concern me all that much because people need to have an understanding that just because you're selected doesn't mean you get a visa. It's right there. But the major screw job is when they schedule people for interviews and the people go and spend like their last $400 to get a medical. They should be able to get a refund of that if they cancel the interview. All right. Because then at that point, you're making them do something that costs them money that is not going to get sent. That's only going to get sent to the embassy.
Right. They should reserve probably those. They could reserve those visas before they actually invite people to come to the interviews. Basically, hold them as in a reserve, and then if the person doesn't qualify, then you can release them at the last second. But
I got to be honest with you. If I unplug my computer and it can tell me to what percentage battery I have left, we should be able to look at the visas that are left and say, okay, you only have 5% juice, plug in, meaning don't schedule any more interviews. Don't let these people go and spend their last dollars traveling for medicals, because sometimes it's the entire family. I don't know. I just feel like no one is really, I mean, I will say, right, the litigation in the last, 2020, 21, haven't really finished with it yet, but boy, did DOS get the record. And now it's like, just blindly, we're not going to do any visas in certain countries. That's okay. Exhaust them where you can. We'll go over the cap. We're going to select 300,000 people and we'll just get rid of it that way. Yeah. But it's tough.
Yeah. And on Go and Gomez, we sound like a broken record, which is a reference that for the younger folks out there, that used to mean something. But nobody knows what a broken record is anymore. But in that case, we have we now hit the 1 year mark since the oral arguments, I think, or it's this week or sometime around now on there. It was September of last year.
Yeah,
we're halfway through September. So anyway, if we're not at the 1 year mark, we're right around the 1 year mark on that. But there's nothing special about the 1 year mark as far as the DC Circuit is concerned. So we we're just as in the dark as the plaintiffs are, as far as when that decision is going to be coming. I don't know what the record is for the longest the case has sat waiting for a decision from the DC Circuit. I have a feeling that there's many other cases that are in that situation right now. The one thing I will tell people is there were 1,100 extra cases in the criminal cases that ended up in the DC courts this year because of over the last 2 years because of the January 6th insurrection and all of those indictments. So every every level of in the DC courts right now, every judge is basically slammed with those cases. So yeah. I'm guessing it's probably just general workload issues, and it has nothing to do with like not being able to make their minds up on this case.
Yeah, I think they can probably figure out the outcome. I mean, they probably had an outcome in mind quickly. At least two of the judges, I would think. I think though, again, we're talking about how do we stop an executive branch that maybe is not following the rules set by Congress. And I think that in DC, that question is the most important question that circuit and that those courts deal with all the time. And so what I would expect the judges do, this is not just a DV case to them, I think. And you have one judge, Henderson, who I don't know. She's just probably writing a dissertation on why. I hope she's writing a dissertation on why the majority is wrong. But they probably understand that this decision is really important for in the future because cases in our system, when you publish a decision, it actually has binding effect in the future.
Right.
They probably don't want to go too far afield, but I don't think they want to see, let's say that there's a change in administration. They probably need to make sure that there are some clear boundaries for a president who wants to shut down immigration. And I'm not a visa applicant, so I the human part of that is, it's I understand it, but I'm not in your shoes in a country where you'd like to come to the United States. I think, though, that I would pay to wait if they get the decision right and we have some real rules that have teeth so that presidents can't just shut down our immigration system, because I don't think we've seen the end of it. In fact, even in this administration, in some ways.
All right. Emily had an interesting question about the visa bulletin, which normally comes out sometime in the middle of the month. So we're expecting the October visa bulletin to be coming out, and there's a lot of interesting things to be looking for in that. But just in terms of news, one is, for example, on EB1 for India, which I guess rolled back to being from almost current a year or two ago to now being 10 or 12 years backlog that happened earlier in the summer. Whether that was just a strategic move by DOS to slow down filings and to slow down processing there, and then that's going to jump really forward. But I guess that the October visa bulletin is a really important one because that's the reset on the fiscal year. So two things largely happen. One is that there's usually a decent advancement if there are visas that are, if the numbers that are about to become available really will change it'll change the date. And the other thing is filing dates from USCIS are also usually there's a discussion that's happening, I believe, between state and USCIS at the outset before October about where they're going to set the filing date chart. And USCIS will usually be pretty good at the beginning of the fiscal year about honoring the filing date chart. And then later on, we've seen it's more likely that they're going to say no on using that chart, which they have the discretion to do in any given month on there. Jesse, I don't know if you have any thoughts about what this question about. First of all, you can't really tell that much about what the backlog really is from the visa bulletin itself on there, because they don't usually give you that much insight when they, when it comes out about what they, why they set this number at this place, whether that was just to slow down filings or whether it's because they genuinely think they're going to run out. But I guess we're going to know in the next couple of days. I do know there's sort of a history as well in the last couple of years of September visa bulletin taking a while before, while they're getting ready. I don't think we're seeing any more of the rollover happening. The consulates, I think, are relatively functioning normally as far as family-based consular processing for immigrant visas. But I don't know. We'll
yeah, I mean, it's a huge, obviously, it's going to set the tone for the entire 2024 fiscal year. A lot of people lost the opportunity when for Indian nationals in particular, Chinese nationals, people caught up in the backlog when it rolled back unexpectedly. And we still have people from 2020 who haven't received an adjudication, amazingly. The EB1A. But, again, we've also seen where the family-based side hasn't moved for some people in years. And I don't know what they're going to do, to be honest with you. I would, I don't.
There's one thing that so this kind of raises questions about like what Congress has to fix and what can be done by the administration. And this is all, there's a couple of things, first of all, that there's a tendency with this White House, and I think to some extent, and definitely we saw it in the Obama White House as well, to listen to the most conservative voices in the agency regarding what their options are from an administrative fix, things that they could do. And obviously that's one of the reasons why they fight so hard in litigation, is because they don't want a court telling them what to do. But they also, in the agencies themselves, to the extent that they could fix things through policy moves. I just know in a lot of discussions that I've had behind the scenes with people at the agency that those arguments happen frequently within the agency about people who would like to be more aggressive in fixing a problem. And people who argue that no, we're going to get sued. Of course, they're going to get sued anyway, whatever they do. But there has been intense lobbying in the past of the White House by people at USCIS and DHS not to do things that they're being urged to do by Congress and by the public, saying that they don't have the legal authority to do it. And that's I think we're seeing that in this context. Couple places. One is there are a lot of people arguing that the statute is broad enough that you can read it in a way that you don't have to count derivatives, that you don't have to count spouses and children. And if you look at the language, it's on the quotas, it reads almost the exact same way as the H4s who don't count against the H1B quota, and that same identical language is interpreted the opposite way in the green card context, where family members do count, even though the language is the same on there. And that would be a way. I mean, you can almost triple the number of green cards that are granted each year if you took that reinterpretation. That doesn't require an act of Congress, and that would substantially reduce backlogs if they did that. And they've had that argument laid out for them. AILA made that argument for them 9 years ago when President Obama put a call out for administrative ideas, things that they could do, and that was all laid out for them. And then internally, I know that was debated, and they said, nope, can't do that on there. Cyrus Mehta has made a really good argument in a blog post recently that kind of laid out a law for it. And this was also echoed by a letter from members of Congress to the White House that that the way that the adjustment of the status language reads, they should have the ability to allow almost everybody to file adjustment of status if they have an approved I-140, or even if it's a pending I-140, arguably. That they only have to. The language says that there has to be a visa available. It doesn't say that, but a visa available, means that they haven't depleted the entire stock of visas, and that there are still visas available in a particular category. So as long as the government doesn't issue all of them, they have the ability to take as many adjustment applications as they want on there, and that would provide tremendous relief to people if they can file adjustment applications, because they would get employment authorization documents and travel documents. They wouldn't have to be dependent on their non-immigrant visas. They would be portable, which means that they could switch employers and start their own businesses potentially. I mean, there's all kinds of benefits, great benefits to the economy broadly for all of us if they did that. They have the ability to do that without an act of Congress. And there is like a long list of those kinds of things that the administration could do, and they're not on there.
Yeah.
So we will see if they get a little bolder. The only thing that is interesting that we've seen is that in an election year, when a president's up for re-election, that's sometimes when we see that kind of stuff happen. And I think the perfect example of that is the DACA program, which was announced in June 2012, when President Obama was not doing well in the polls. And really needed to get a good turnout of Hispanic voters. So if I'm looking at it really cynically, that's why the DACA program was announced in the summer of 2012. It wasn't coincidence. It had a lot to do with an upcoming election. So it could be, as well, that we'll see a 2024 with a lot of things happening that basically under the expectation that Congress is not going to fix any of this stuff themselves.
Yeah, well, I guess we'll see. I mean, what I hope they can avoid is wherever they set the limits in October, we don't have another summer surprise where they basically just made them all unavailable and did it without there needs to be a little bit more transparency on what is available in the inventory.
Yeah, I'm just posting Alice and comments in which we just talked about that case, but yeah, we're never giving up. That's that's certainly the view. Yeah. I'm guessing we could win in the DC circuit, and we could still be, facing the government not giving up on their side and trying to take the case to the Supreme Court. So we will see. Emily was asking this question about policy question on biometrics for H4s, whether we see anything happening in that, any changes happening.
I mean, I don't know if we'll have to sue again on that, but that was that was a Trumpian effort to really frustrate processing for H4s, and we sued on that when I was at AILA, and they removed that. I guess I don't understand. I mean, how they would justify bringing it back because they would get sued again and say.
So speaking of that, was the Adequani suit, correct?
Yeah.
Right. So somebody asked me this question. I said, I'll have to ask Jesse, because this doesn't make any sense to me that there is an effort afoot at USCIS to try and argue again that case was limited to the relief was limited to the plaintiffs and
the processing, I guess the waiver of biometrics did have a sunset on it. There wasn't forever, unlike L2 and
right. I mean, I guess the question on it is that even more broadly on there, but to the extent that it sunsets, it would be for everybody and not just even the plaintiffs would potentially.
Oh, if they were still, yeah, it would. They don't get. It wasn't anything specific to them where they get they never have to do biometrics again, only them. No, it was the entire idea of biometrics for H4s. Like, is it required or not? And we said it shouldn't be for 2 years and the point was, it was a couple things, but mostly the biometrics that were implemented, the requirement really blew out H4 processing times to something that, basically ended H4s from getting work authorization, right? Which was the intent. So if they were to do it again, I mean, we had arguments in that case as to why H4s had to be adjudicated concurrently with H1s, and we could always bring that back if we had to. I don't think USCIS wants to tangle on that, but we could. We'll see. I mean, I don't. I'm not privy to what USCIS is doing, but I don't think that they. I don't think they. I mean, they've waived biometrics for so many other categories. It would make. I don't know how they would justify bringing it back.
Yes, we're wishing Chuck a speedy recovery. He said this morning by text to us that he's actually doing pretty well, so that's good. In favor of the government, and there has been no ruling. I guess arguably there was the ruling in favor of the government was the delay in our case, depending what's going to happen on the appeal of another case. At this point, but we haven't actually had any ruling in favor of the government on our specific case. It's just basically been put on ice while this other case is working its way up in the Ninth Circuit. Jesse, is there any?
Yeah, not in our case. I mean, there's been a number of cases where a judge has ruled in favor of the government, and there's been one now in Colorado where the judge went the other way and ruled in favor of the plaintiffs on a motion to dismiss, but not in our case.
Right. Okay. Continuing on, and before we leave as well, there was a couple updates I was just going to give on changes and things that happened in immigration law in the last couple of days. So more questions about Go, and I think we kind of addressed it, which is that we don't have an answer. And look who it is. Britt Simon. We're at least seeing a government determined to issue all the visas. That's better than right. So I mean, you can't. I mean, we have to. I agree with that. That it's good. It's good news on there, and they deserve credit that they didn't leave any left over. We know that was certainly not the case in previous years. Whether they can do a better job in terms of allocating and also being fair and being better at customer service while they're going through that is that's certainly an issue. I think the lesson that Jesse, that you were talking about before, is that don't count on the government to be to honor, basically, to do the right thing, which would have been in case what they're asking you to spend money and get to an appointment and do all this other stuff, that means you're getting the visa at the end. You just have to know that's basically at this point the cost of doing business with the government. If you're going through this, and there's especially at some consulates, it's that there's a decent chance that you're going to do everything right and in a timely manner, and you're still going to have a problem on there. And that's unfortunately the way the system works. And it's not an easy thing for us to sue on that particular question. We can sue if they don't act, on the go when they're not issuing the visas at all. But when they're doing it in a way that's really not, not fair.
I mean, it's if you get selected, it's almost, I don't know. I mean, again, it's a lottery, right? It's a lottery when you're selected, and then you have to understand that they are going to select maybe 2 times as many visas for people as there are visas available. I think the only kind of guidance you would give people is your chances of getting a visa are so much higher if you can file for adjustment of status in the United States, because USCIS is absolutely rock stars on how they implement adjustment of status for DV selectees. I mean, Britt and I have talked about this before, and he knows it fully well. I mean, USCIS really does take that category seriously, and they do make unbelievable efforts to adjust everyone who has a visa available to them.
I don't know what the Britt would probably be able to would probably know this off the top of his head, but this is seems earlier than we've ever had DV. I mean, usually it's like, to the extent they even say that they've used all the numbers, it seems like it's, in my recollection, it's always been at the last moment.
Oh my God,
that's been almost a month out before the end. So this is fairly unusual, It's not normal, and I think probably it caught some of the lawyers by surprise too, and may even have caught some of the consular officials off guard that they thought we had more time.
I will say, and I do a lot of consular work, so I'm just gonna like get on soapbox here for a second. It does show that admin processing does not have to take years and doesn't even have to take months, right? And like so many students right now are missing their start dates because they're trapped in this maze of, here's a DS 5535, even though you're an 18-year-old student, and we're going to send you to Washington, and you're going to sit and wait, and then you're going to miss your admission date, and then you're going to have to defer. So now you're not. And I just think that we need to have that they've shown with DV that they can process visas, even for people who need extreme vetting, extra vetting, admin processing, whatever the hell it is, they can do it. And they need to do a much better. They're killing part of this. And what I've seen is this, and I'll tell you, and I know it's intentional. If you are not a friend to the United States, that means Russian, Iranian, right now, Chinese national, Middle East to some extent still, they are really putting the screws to the nationals of those countries across every visa category.
Yeah. The only exception, I think, and it sort of just shows, I think, sometimes the politics matter, are doctors on there. And we do a lot of work for doctors. And even in the Trump administration, they had to face reality that it has much wider implications when they screw over a doctor as far as being able to get, that they have a hospital emergency room that's going to close down because they don't have they can't meet their accreditation requirements because they can't get their anesthesiologist or their surgeon in there. So it's when they want to, they can figure out policies and ways to expedite and make sure that people get here on time. But also, we did see, even with travel bans and all that, with students that, especially when Harvard and MIT stepped up and sued on there, that they can fix a problem quickly for when they want to on that side of things. So I'm not, I think you're right on there, and especially for some countries, it's really bad, and they may see individual students, as expendable versus sort of the whole student program, where they might look at it differently.
Yeah, but I've seen a lot of J's getting caught up, to be honest, from Iran, and it breaks my heart. Not breaks my heart. I mean, listen, I just do a lot of work for a lot of good people who are trying to flee a bad situation, and they get handed and they miss. And you're putting a lot of pressure on the exchange program, and you're putting a lot of pressure on the institutions in the United States, who I've actually talked to now more and more, because I'm trying to get people to get deferred and things like that. And they're like, hey, listen, we have so many people who want to come to this program. We cannot wait forever. And so then the school gets pressured. Do we not select these people for the program, for a PhD in engineering? Because this person's not going to be able to ever come here, we think, because of what's happening with admin processing. It just, we need to not pretend this is not happening. And it's and to be quite honest, the government has taken a litigation position for a lot of these delay cases, especially for Iranian nationals, that they're going to fight them to the death, and they're going to say that there's never a delay that's unreasonable, even if you miss your start dates, even if you miss your program. So anyway, that's my speech for the day.
I'm just posting a couple of Brits explanations as far as what's been happening with the lottery this year. But apparently I guess it's 6 years since the last time we had anything like this. So that's interesting. Okay.
Was that no 6? I was going to say that was another election year, but it wasn't. I don't know.
No, it was Trump though. Just in terms of news for this week, there just were a couple of things that are worth noting. One is that if you are in the EB1 or trying to get EB1 as a STEM professional. Note that there were some important clarifications on and a lot of details about evidence that have to be submitted to USCIS for those cases for STEM professionals. And basically what they've done is last year they released O1s, all these new evidence criteria, which for the most part are good. They give you a lot more guidance as far as better arguments for the lawyers as far as things that the way we present evidence. But they did that for the EB1 A and B categories, I believe, this week. So that was news. There was also news regarding TPS and a 540-day a 540-day extension on employment authorization documents for people that filed for extensions of TPS to EADs in a timely manner. I believe that was news this week. And I think that's it, Jesse, as far as the things I want to mention. Maybe it was last week as well, that there had been new TPS designations, redesignations, re-registration periods announced for El Salvador, Haiti, Honduras, Nepal, Nicaragua, and Sudan. So if you're TPS, also note that you need to start getting ready for that. Anything else, Jesse, as far as news or any changes in the last week?
Not that I've seen.
Okay. All right. Well, we will end there. And like I said, hopefully there'll be 4 smiling faces next week. Probably at least 3, maybe 4. We'll see. I don't know, Jesse, if you're here or not, but hopefully. And wishing everybody well. We'll see you next time.
All right. Thank you.
Bye-bye.
All right.